to answer some of the questions that have been coming to me on what are we going to take up in this workshop on disaster law and community preparedness. These are important questions, and in brief, roughly, I'm going to answer some of them that you know what exactly are we going to take up. We start from the right to life, which is Article 21, and from there we get into the provisions of the Disaster Management Act 2005 and acts of Bangladesh, Sri Lanka, and other countries in South Asian region to compare the Disaster Management Act in its ability to deliver the right to life to people. This is about distinguishing between acts wrongful by nature or mala in se and those that by nature are not criminal, but they are mala in prohibita or prepared, or much of the preparedness studies focus on what is not criminal by nature, but they become criminalized because they are prohibited by law, and yet many of the decision makers continue to undertake that, and the Disaster Management Act has this major gap in it. Taking it further from the Blackstone commentaries on what is a violation of public rights and duties, and the 4 elements of crime against nature. So the focus on actus reus and a result of a deed prohibited by law and a result of human conduct. We go further into other fundamentals of law to be related to disaster situations and how decisions are taken prior to a disaster and during the disaster and post-disaster. The laws related to ignorantia facit excusat, ignorantia juris non excusat. Some of these fundamentals are to be related to the Disaster Management Act and understood in a larger framework of law. Defining consent to mega projects, which is again a major gap in how we understand environment and the mega projects. The Indian Penal Code and its relationship to the culpable homicide that happens when disasters occur. Who is responsible? The people, the decision makers, or the project managers. Unless we define this, this is going to continue. Then the accountability principles. An act done against my will, is it going to be my act? We provide answers to this. And there is much in jurisprudential history of law where we can definitely relate the Disaster Management Act. Going further, provisions related to the health of workers, occupational diseases, hazardous processes used in factories, and the various acts that combine and should be combined with the Disaster Management Act to provide the workers' rights to occupational safety and prevention of hazards against their life. What is the duty of the employer, and how do the contracts function when pandemics and disasters occur, which is force majeure, the clause that is to be included in the contract. Further, going into international humanitarian law, Pacta sunt servanda, the agreements are to be kept. Rebus sic stantibus, the situations permit waiver of certain situations. How do we define the gap between the two? We sign agreements, and then when these agreements are to be accepted within our national laws, how do we take them? The Hague Conventions, the Geneva Conventions, the role of the state and non-state actors and international humanitarian law, all this need to be studied in a wider framework, not in the narrow framework of various regulatory designs that are created for us to understand disasters, and we keep going around them to find what is legal and what is illegal, what is a crime and what is innocence. And that is what we are going to do in the workshop that makes our workshop extremely different from the other workshops.